Hi, I'm Steve Carlson, the 2016 independent candidate for President of the United States from Minnesota. And I've been the nominee for the Minnesota Independence Party for the U.S. Senate against Al Franken and Mike McFadden. This is the third video on the action at the Minnesota Supreme Court on free and fair elections. And I'm briefly sharing some of my positions in this series. I've talked about immigration, religious liberties, climate change. I've talked about consumer spending and 35% of households in collections in a recent survey. And I also want to disclose a couple more of my positions, including the national debt and trillion-dollar deficits. My fellow Americans, there is simply no way that we can sustain this kind of massive debt. Perhaps somewhere down the road, we could ask people to write it off. But that still is not going to solve the problem, because we will be in bondage to debt. Is that the freedom our founders envisioned and that we received as our heritage? We are destroying the economy of future generations, possibly forcing the nation into socialism, like Obamacare. What we can do to reverse this is to turn the power and resources back to the 50 states by transitioning functions like Obamacare, like the Department of Education, and each function not constitutionally committed to the central government, back to the states. This is the only way to lower taxes. It is simply not true that we can protect our future by growing the economy so that our national payments, annual payments on debt and interest, are somehow proportional to our national domestic product. Folks, it's not working. And padding unemployment numbers with part-time and low-paying jobs that can't sustain the rent and basic needs of life is not going to change that. Secondly, on health care reform, instead of a dangerously huge and ineffective socialist-like health care system called Obamacare, I want to restore the free market system and the ability of insurance companies to provide health protection, including employer-based plans. I believe emergency room safety nets should always be with us. But I want to proactively target health disparities, that is, patients who are at greater risk to killer diseases, cancer, heart disease, lung disease, multiple sclerosis, diabetes, and Alzheimer's, and the like. I want to target these killer diseases and health disparities with effective research, prevention, and education, and programs put in place to provide standard treatment so people will have a better chance to fight these killers and enjoy a higher quality of life. I have always taken as my model BSEP, the National Breast and Cervical Cancer Early Detection and Treatment Program. And since I took this position, it has saved my own wife's life, and I am grateful. And I want all Americans to benefit from this kind of public-private initiative to save lives, not just money. I want to strengthen and protect civil rights and human rights. And I have positions on many issues I've developed since I first became the nominee for Congress in 2010. I'm a radical centrist and a problem solver. And I think voters want someone like that in any presidential race. But as I said in the first two videos, in Minnesota today and throughout the nation, the two national parties, the Democrats and the Obamas and the Clintons. I don't think the Obamas are quite a party yet, but the Democrats are now a dynasty of Obamas and Clintons, while the Republicans are of the Bushes. And these two parties, national parties, have conspired to trample on the rights of independent voters. And you don't hear a lot about that from the Republican candidates, and we need to hear their voices too, or from the Democrat candidates, although today I'm going to tell you about the Hillary Clinton solution to easy access to power. They're promoting their own national agendas to get an edge in 2016. Now in video 2, I introduced George Newman, who has responded to these videos extensively on Twitter. He responded to my claim, which I have clearly shown, that Hillary Clinton's Democrats are abridging and denying voting rights in multiple states. It's reached the point where Newman, who is licensed to litigate election law in Virginia, Maryland, and the District of Columbia, has suggested I might be jailed if I don't drop my allegations, public allegations, that the Minnesota Supreme Court has deliberately covered up and excluded from the record the clear fact that Minnesota Governor Mark Dayton, former Governor Mark Ritchie, and Al Franken conspired and colluded to illegally issue Al Franken's election certificate to the Secretary of the U.S. Senate, while Franken was still facing this contest. So let me first address the voting rights violations by the Democrat Party, which initially drew Newman's attention. So there are a huge number of independent voters in Minnesota and the nation, and this election litigation, which I am bringing myself pro se, I'm not a lawyer, is to restore those rights. I'm fighting for voting rights, which are being denied in Minnesota based on gender, based on race. In the state of Minnesota, during a time the Democrats controlled Minnesota state politics, have passed a new law to abridge and deny participation in voting based on sex, based on race, and based on suspect classifications, in clear violation of the United States Constitution. In litigating to achieve free and fair elections, I'm building on a successful U.S. Supreme Court case from the 1980s called Anderson versus Calabrese. The case is about independent voters and their parties. But since Anderson has been decided, it's been Democrats and Republicans who have seized on the decision and declared that it is to protect their rights of association against independents when the case talks about the need to protect independent voters. And just as Betty McCollum went on the offensive in my 2012 House race, charging that voter ID laws and other regulations on voting by the states constitute discrimination, and I've clearly shown that this kind of election law of voter regulation is critical and directly called for by the U.S. Supreme Court and by the U.S. Constitution. And that was in a case that originated in 1932 in Minnesota called Smiley versus Home. And now Hillary Clinton takes up the chant to fire up her base. This is a national election strategy by the Democrats intended to heat up political rhetoric and pretend to give substance to her campaign. She won't take interviews, won't answer questions, but she's quite sure Republicans are cynically suppressing voting rights. And so just yesterday, the partisan Washington Post reported that Hillary Clinton is already leaning into the ever-simmering battle over voting. Her Democratic allies are preparing to wage a national legal battle. They can go to court against GOP state-level voting restrictions, and she is calling for a national 20-day early voting period. But now Clinton is rolling out another proposal in her push for an expansion of voting access, or voter access. In a speech in Texas that is underway yesterday, she is calling for universal automatic voter registration, obviously dovetailing with Obama's unconstitutional measure to bring millions of illegal immigrants into the 2016 election. This kind of violation of the rights of the 50 states to regulate voting would destroy the comprehensive congressional election code in each state called for by Article 1, Section 4 of the U.S. Constitution, which I've been discussing extensively, to prescribe the time, place, and manner of election of each state's representatives in the U.S. House and in the U.S. Senate. WAPO, what I call the Washington Post, reports further, quote, automatic voter registration for citizens has long been championed by voting reformers as a key part of modernizing our voting system. Clinton's proposal would require the registration of all citizens in every state when they turn 18 years of age, unless they opt out. Now, how we're going to know they're citizens, I don't think anybody knows. She is also endorsing the general goal of universal registration for those over 18, without endorsing a specific mechanism to accomplish this. Specifically, she would be endorsing Steve Simon, Mark Ritchie's successor, and Mark Dayton and Lori Swanson, somehow putting into effect a way to affirmatively add people to the voter rolls. And Democrats are going to use the bogus argument, we should all have an easy way to vote and share in political power, unquote. This is a far cry from the U.S. Constitution. And I've already told my audience and told the Minnesota Supreme Court, and am trying to tell Congress, that the Democrats are violating the guaranteed right to elective franchise by the Minnesota Constitution at the precinct caucuses by excluding voters based on gender, based on race and based on sexual practices, a certain percentage of those elected have to self-identify as homosexuals or lesbians. I'm talking about elected as delegates, voting delegates. And the only way to understand what Clinton is doing now is she's trying to force everyone into this kind of unconstitutional social engineering, which I first attacked in my 2012 race with Betty McCollum, and then was subjected to the loss of rights, the loss of voter email addresses to carry this message to the voters during the election. WAPO reports that, quote, according to the Brennan Center, there are various ways to add people to the voter rolls, such as when changes of address are filed. States can also implement required universal registration for people of all ages, as Oregon has done. Clinton cited Oregon as an example in Texas. Voting reform advocates favor universal automatic registration as a way to streamline and simplify the registration process, to eliminate matching problems between state databases, reduce the possibility of voter registration fraud, supposedly, and maximize voter participation. In political terms, Clinton's call for universal voting registration appears to be a bid to energize millennial voters. As it is, the broader voting access push, like her recent moves, WAPO calls it leftward, on immigration, as I mentioned, climate change, and sentencing reform, is partly about mobilizing core Obama coalition groups, including minorities. Now it's minorities. Today's proposal is more heavily focused on the young. After all, one of the key unknowns of the cycle is whether Clinton will be able to turn out Obama voters on the same levels he did, and younger voters who are excited by the historical nature of Obama's candidacy and the idea of a new history are key to that. And Rick Hassan, a voting law expert, told Greg Sargent, who wrote this for WAPO, there's a good reason why Clinton might support universal voting, but there's also a good political reason, good policy reason, good political reason, he says. These are issues that motivate the Democratic base. Talking about Republicans, suppressing the vote, gets Democrats excited, just like talking about voter fraud motivates Republicans. Indeed, Clinton's proposal today seems likely to draw opposition from conservatives and Republicans. For one thing, they would probably seize on the chance to attack her for favoring another government mandate and federal encroachment on states, and also to argue that government-mandated registration could produce other types of fraud. The Clinton camp will probably try to pitch this proposal and her push for more voting access in general in a way that rebuffs GOP efforts to turn independents, like myself, against it. So that we're gonna buy into what Hillary is laying down, casting it as a key to maintaining the integrity of the process. Now, this is just the way Greg Sargent writes. Indeed, all the mainstream media must have a style book which tells them to push the party line, according to which the only ones who ever object to the deterioration of our Constitution are Republicans. Well, I'm an independent, and I'm saying, and have been saying, that the Republicans themselves are refusing to enforce the voting rights protections set out in our state law in Minnesota and required by the United States Constitution and Congress. WAPO continues. For another thing, as Hassan has noted elsewhere, the battle over voting access revolves around a much deeper dispute in which some opponents of increased access have explicitly argued that making voting harder actually leads not only to less voter fraud, but to more informed choices. There are two ways of thinking about voting, Hassan tells Sargent. The first, which is associated with conservatives, is that voting is about choosing the best candidate. Well, imagine that. If you take that view, you might want restrictions that winnow out uninterested or uneducated voters. Democrats and liberals are much more likely to take the second view, that we should all have an easy way to vote and share in political power, unquote. Again, through voter quotas in Minnesota and spread across the country, Democrats are socially engineering and re-engineering the vote, and they are getting the protection of a Republican-led Minnesota Supreme Court. And so on December 19th, while a contest was pending against Al Franken, They looked on as Dayton, Franken, and Ritchie protected this sexist, racist, anti-Christian, and unconstitutional practice by surreptitiously slipping Al's election certificate, helped by Washington lawyers, who Newman says he or she probably knows out there, to the Secretary of the U.S. Senate. And Al Franken used this phony document to take his seat in the Senate January 6th. And I'm trying to fight this political corruption. But the Republican Chief Justice, appointed by Tim Pawlenty, has issued a train of baseless orders claiming the court and Minnesota courts have no responsibilities they must undertake to regulate the federal elections in Minnesota for either the U.S. House of Representatives, that's Betty McCollum, or the U.S. Senate, the professional entertainer Al Franken. Famed authority and author of Rush Limbaugh is a big, fat, stupid idiot, and other greats. And naturally, the Republicans here don't like Al, are embarrassed, but they're not motivated to regulate the Senate elections so they're free and fair. Instead, they're excited, and Sarah Janicek, and I believe Chief Justice Lori Gildea, are two of the GOP partisans in Minnesota who are excited to be rid of the Independence Party of Minnesota, who they buried in a show election in 2014. And I'm challenging this action by Gildea and the Republicans on the court. So, George Newman, thank you for your inquiry, and let me show you more of the proof I promised you of voting rights violations by Democrats in Minnesota, and their other serious material and deliberate violation of provisions of Minnesota election law and irregularities in the conduct of the 2014 election between myself and Al Franken. And yes, there was a Republican I've never met, Mike McFadden, who I understand is off making money now. To continue what I'm telling the Minnesota Supreme Court that Newman thinks should land me in jail in our free America. And then I learned that this court in Ramsey County would prevent me from pursuing this in a contest. So the facts of this case are that there was no contest in 2012. It was filed but mailed back and not allowed to proceed. Two of the claims were improperly barred under the theory of laches, finding essentially that Betty McCollum would be injured in her entitlement if forced to face an election contest, and that this required that I have filed a petition like this one before the election of 2012. You found that I would have needed to bring the voter email case as soon as I learned October 29th, 2012, less than a week before the general election, that I would not get the voter email addresses that I was promised and had paid for, and that would not have injured the right of Betty McCollum if I had filed that petition not to be challenged on the voter email question, even though it turned out she was calling for voter emails to be kept from her opponents during that election. And that was nicely complied with by Mark Ritchie, her DFL colleague. You ruled that the refusal of Ramsey County District Court Judge Elena Osby to allow the election contest I filed did not have a close enough connection to the election of 2012, so a hearing ordering the district court to proceed with the contest would be considered within the ambit of 204B.44 as related to an election. So an election contest has no relation to an election according to the Minnesota Supreme Court. With all due respect, that is too preposterous a pretext to be taken seriously by anyone. But you held your power as the arbiter of federal elections in Minnesota in defiance of the requirements of the U.S. Constitution and its framers, or the powers of the U.S. House of Representatives in that case. And it was this insight into the Minnesota Election Code which was then applied to bar the petition of the Green Party when they lost their minor party status. Somewhat different, I'll discuss it. So now Chief Justice Gildea finds, in refusing once again to apply Minnesota election laws, Minnesota's Statutes Chapter 209, that I, quote, disagree with the outcome of my previous election contests. And I disagreed because the state officials I've named have wrongfully advocated the violation of Minnesota election laws in federal election, congressional elections. Then I learned that Amy Klobuchar and Al Franken could block Independence Party Senate nominees from U.S. Senate debates, legally or illegally. So I coolly, methodically, investigated and documented a determination that the debate organizers, all FCC licensees, were really going to go through with this. And your parties, the DFL and Al Franken, and your Republicans on the court, and Mike McFadden, were going to squeeze me out. And that your Republican analyst, Sarah Janicek, who had said to your at-issue media talking head, Tom Hauser, who said for sure the Independence Party would be eliminated as a result of the 2014 election, the very one I'm bringing before you now. She said the party had to get big names to run for the Senate, and so fighting for democracy, as I am doing now, for free and fair elections, became my number one campaign issue. Because your court will not regulate the elections under Article 1, Section 4 U.S. Constitution, which is required to protect the vote that is enshrined there, as found by the U.S. Supreme Court in Ex parte Yarborough. I had to take all the steps to open up debates to a major political party nominee. I am not merely the candidate. I won a statewide election, like every one of you justices who were in re-election. Do you know what that means? Probably not, because you don't have opposition in your re-election, but I do. And I became that nominee because I won against the endorsed candidate and 3 others in a statewide primary election. And by you refusing to enforce regulations of federal elections as prescribed, Al Franken was able to negate and void that primary win and become a big political leader in eliminating the Independence Party spot that was there since Perot. Exactly as Sarah Janicek boldly predicted on At Issue. Because you say you will not do anything to enforce the First Amendment and equal time provision. But in 2002, when NPR acted against Jim Moore in Moore versus NPR 2nd District 2002, because Walter Mondale excluded him from a debate in the final days. The Ramsey County District Court acted on this very question, but just for one final debate. For me, for my party and voters, you turned up your noses for the entire debate season. And as a result, our party was under assault. I was under assault, bombarded by the typical political slander the not-so-dignified National Democrat and Republican parties engage in. But I had no rights of freedom of association or freedom of political expression as their candidates and voters, their national party had. The results were tainted by these invalid procedures, this invalid election, and I am challenging the validity of the election which selected Al Franken and eliminated the Minnesota Independence Party on the grounds of serious, material, and deliberate violation of election law and irregularities in the conduct of that election through voting rights violations, First Amendment violations, and ballot access violations, equal justice violations. Now, all of this, the unconstitutional race, gender, hetero-baiting, and I'm just going to really quickly check this recording. I'm an independent voter and an independent candidate, and we're pretty short on the resources that the national parties have, and so I have kind of ad hoc technology here. Now, all of this, the unconstitutional race, gender, and hetero-baiting backed by state law, social engineering, the denial of the use of public information, even though no one doubts in the record that it was a practice for years in OSS, and the refusal to debate and to broadcast about the IP candidates, only that they were arbitrarily excluded from those events, and that the remainder was the Minnesota Senate candidate debate, sans Senate candidates. All of this is supposed to be res judicata, because all these rights, questions, or facts were supposedly distinctly put in issue and directly determined by a court of competent jurisdiction. Therefore, the order finds that in part, a principle of finality prevents the bringing of this petition. And any complaints about this, said Gildea, are predicated on, it doesn't really say motivated by, my personal disagreement with your previous actions. So there's absolutely no factual or legal predicate for these accusations and pronouncements from the Chief Justice, the appointed and re-elected Chief Justice. And so Gildea finds any objections, Any objections to this shield you provide against free and fair elections in our U.S. Constitution fall within the catch-all category of, quote, any and all disputes concerning official conduct that relates to an election, unquote. And the court finds this is so because of a case called Minnesota Majority versus Ritchie, where that organization sought access to statewide voter registration lists 6 weeks after the 2008 elections. This has no application to my case, as I show infra. What I have just shown is that the court in the challenged order has first of all made a bald accusation that I am motivated by dissatisfaction as opposed to true legal arguments, and so you have overlooked the facts on this case, that I am presenting only facts and the controlling statutes, decisions, and principles of law and material questions in this case. Based on all these, do you or do you not have a duty to, I know what you have always said, but the question is, why do you say, what is your duty to say what you have always said in this case, on these grounds, for contest and petition? Your order conveniently overlooks, I would say deliberately excludes, to falsify the record on appeal to the United States Senator, U.S. Supreme Court, the plain point raised that Governor Dayton, former Secretary of State Ritchie, and Al Franken, elected in 2008 as senator, conspired and concluded to illegally issue an election certificate claiming there was no contest on December 19, 2014. It does not matter what happened on December 26, 2014, when I took appeal to this court, or when I appealed from the March 2015 refusal of the panel to take note of this and to remedy it and to void and vacate it, because the contest was not allowed to proceed because they immediately sent the certificate off to Washington before the contest was even concluded, in violation of Minnesota state law. Because the law at that point, on December 26th or March 2015, was already violated. That is what we're looking at, and it remains violated because that certificate is still out there, purportedly as if it was officially and legally issued. And the certificate presented by Mark Dayton and Al Franken was issued in violation of the law. In the eyes of the law, the certificate must be a nullity, and the contest must be void, and actually is a farce and a travesty, requiring voiding, and the contest should be completed. In addition, the entire record and transcript should be provided to all the parties, forwarded to the Senate and House in Washington, so they may be made aware of the irregularities in federal elections in Minnesota. This should include the Supreme Court actions of Minnesota Supreme Court actions and records as well. So here's some more analysis. That the Minnesota majority cases, as cited above, do not give the court the right to deviate from the language and procedure of 204B.44, and you should consider the petition and have a hearing to order compliance. Most of the analysis below focuses on looking at the twin 2009 petitions, Franken versus Pawlenty and Coleman versus Ritchie, which is really Coleman versus Franken. So really it's Coleman versus Franken, and these would be Franken versus Coleman and Coleman versus Franken. They each brought petitions, because this was a huge mammoth case which apparently moved the court to stay clear of election controversies. So it is a good place to begin, and to put the order's foundation in excluding all issues except ballot issues under scrutiny. This is highly erroneous and must be reversed, and it seems to have really started in the Franken 1 petition. In that case, this court considered how Minnesota's laws, formed under the broad grant of authority of Section 4 of Article 1 of the U.S. Constitution, dovetails with the authority of the Senate under Section 5 of Article 1. You explained why a Chapter 209 election contest does not usurp the state's powers, as Franken argued. And you wrote, with respect to the second question, the court in Rodebush concluded that a recount would usurp the Senate's function under Article 1, Section 5, only if it frustrates the Senate's ability to make an independent final judgment, unquote. Minnesota Statutes 209.12 explicitly acknowledges the Senate's authority under Article 1, Section 5 by limiting the scope of an election contest for congressional office to the question of who received the highest number of votes legally cast in the election. Well, of course, it doesn't do that. But that's what the court wrote. And as such, it's dicta. Well, it is dicta. It's just words. It isn't material to decide whether Al Franken's election certificate could issue at that point in 2009 when there was still a contest. Moreover, you continued, moreover, by requiring the court hearing the election contest brought under 209 to preserve all evidence and transmit it to the Senate upon request, Section 209.12 does nothing to frustrate the Senate's ability to make an independent judgment as to which candidate to seat. An election contest under Chapter 209 therefore does not usurp the state's power under Article 1, Section 5 to judge the qualifications of its members. But surely in this, and that's the end of that quote, but surely in this case, where you know that during a contest the governor and secretary of state helped their same party incumbent, just as they helped McCollum in 2012, but in this case you know the certificate has issued. The collection of evidence on these issues thwarted, and this is the very definition of usurping the Senate's function, because it frustrates their ability to make an independent judgment on these excluded matters, which are related to Franken's right to office. So while a contest would not do that, but the evisceration of that contest in 2014 definitely is doing that. In other words, if there was a contest, it would not frustrate their ability, but eviscerating that contest, as they've done, definitely does that. And the release of the record of this at this point would highlight that loss of integrity. But should this court heed this petition and pull the certificate, Franken would continue to operate as a senator and allow this contest. These critical voting rights, equal justice, associational and expression rights, and ballot access questions could come before the Senate, come before the House, and also before this court and potentially the U.S. Supreme Court. But the passage above also finds erroneously that Minnesota Statutes 209.12 explicitly acknowledges the Senate's authority under Article 1, Section 5 by limiting the scope of an election contest for congressional office to the question of who receives the highest number of votes legally cast in the election. And so what's wrong with that? Well, what's wrong with that is that they are misreading the statute to limit the Senate's authority, to say to the U.S. Senate, you can only decide about who got the highest number of votes legally cast. Well, that's not true. The Senate has passed all kinds of election laws. They passed the Voting Rights Act. The Congress helped to generate the First Amendment, the 14th Amendment, the 15th and 19th Amendments. All of these came from Congress. They've passed the equal time provisions in the 1934 Communications Act so that the media cannot manipulate and take away the rights of legally qualified candidates for office. And they've just done a number of things, and they're not limited just to deciding who to seat. They can regulate by passing laws, and they could punish Al Franken for this. They're telling me they want to put me in jail. I'm saying that the Senate could take some disciplinary action against Franken for this conduct. Well, where did this come from? Because it clearly contradicts your finding in Coleman versus Ritchie, where the ballot questions in A, B, and C of 204B did not preclude the use of Section D, which is any other wrongful conduct, omission, or error by any individual charged with a duty concerning an election. And this included admitting votes all agreed should be admitted without a contest. So that was something that was done in the petition. That did not have to do with whose name was on the ballot where, how was it spelled. But this could also be reached as irregularities in the conduct of the election, which I have also asserted in the contest. And so it's properly asserted in the contest. So see infra analyzing Coleman versus Ritchie. Well, where did this idea come from? It came from Al Franken. Al Franken argued, you say, in the decision that Al Franken's contention that the contest tolling provision does not apply to the United States Senate elections. This is what he thinks. is based on the triggering phrase, and him and his Washington attorneys, by the way, thought this. And David Lillyhouse, who's now on the Minnesota Supreme Court, appointed by Mark Dayton as soon as he illegally sent McCollum's election certificate when a contest was filed. But he contended it does not apply to the United States Supreme Court election, or United States Senate elections. And his contention is based on the triggering phrase in the statute, writes the court, until a court of proper jurisdiction has finally determined the contest. And they cite 204C.40 subdivision 2, which is what I'm citing. He asserts that this phrase means the tolling provision only applies to an election contest that can be finally determined by a court of proper jurisdiction. Franken contends that the tolling provision therefore cannot pertain to a contest for the Senate because there is no court of proper jurisdiction that can finally determine such a contest. Franken's contention that no court can finally determine a contest for the Senate is based on the broad authority of the Senate under U.S. Constitutional Article 1, Section 5 to make the final determination about the election of U.S. senators, and also the limited authority provided to a court in an election contest for the Senate under Minnesota Statutes 209.12 from 2008. Now, under Section 209.12, in a contest over election to the United States Senate, the District Court is authorized to make findings and conclusions only as to which party to the contest received the highest number of votes legally cast at the election and is therefore entitled to receive the certificate of election. Well, that's true. But then they continue. Evidence may be taken on other points, not just that point, but they write right there, other points raised in the notice of the contest, which go to Franken's right to office because it's an invalid election. But the court, they write, does not make findings or conclusions on those issues. They don't judge. They can't block a contest, but they're blocking the contest. Franken's implication, apparently they write, is that because the court does not decide those other issues, it cannot finally determine the election contest. Further, because the ultimate determination of all the issues presented in the contest is within the constitutional authority of the Senate to decide, Franken concludes no court can make a final determination of the contest. So Al Franken was trying to gin up an argument that the Minnesota law couldn't make sense if the contest was allowed once he got ahead by getting the boxes of votes from Hennepin County. And so he said once he got ahead, there could be no tolling provision because that could only be triggered by the Senate making the final adjudication as the court of competent jurisdiction, not Minnesota courts. Well, if this was true, Coleman could have made the same argument once the recount contest began. Obviously, it's off base. But your heir to the U.S. Minnesota Supreme Court, in writing that 209.12 statutorily limits the contest to the highest vote count, was in response to Franken's suggestion that that's all a contest could be about once he was placed in the lead. And you were indulging his misrepresentation. And now the issue is there some special reason that is not mentioned anywhere why these fundamental fairness issues of First Amendment, voting rights, equal justice, and ballot access for independent voters and small parties cannot be protected as voter protection under the broad grant of authority to Minnesota under Section 4? And obviously there is not. So then the question becomes, why wouldn't it be enforceable under 204B.44? And upon examination, this court has found no reason not to allow these questions. It's also not at all clear why a hearing on these with respondents may not be held. Orders made and findings reported precisely as called for by 204B.44. Now let's talk about Coleman versus Ritchie. We talked about Franken versus Pawlenty, which was an election petition under 204B.44. Now we're going to switch over to Coleman versus Ritchie, another election petition brought under 204B.44. So Al Franken lost the original count against Norm Coleman, the incumbent elected in the election of 2002, where Walter Mondale came in the last week following the Wellstone tragedy. Despite NPR helping him by excluding the IP candidate Jim Moore from the debate, Coleman won the debate against Mondale, or won the election against Mondale. I'm not clear who won the debate. He appeared to prevail against Al Franken in 2008 as well, Coleman did. But the race was so close, there was a widely watched mandatory recount. The race took a turn when the canvassing board determined that some boxes excluded in Hennepin County should not have been, and corrected the situation by bringing these votes in. They were predominantly Franken DFL votes, and it turned the election in his favor as the nation watched. Immediately, Franken filed his own petition, Franken versus Pawlenty, demanding that he be seated on constitutional grounds in order to give Minnesota 2 senators and get him there because the Senate had already started. And besides, he wanted to watch SNL. Now, at the same time, in Coleman versus Ritchie, Coleman wanted to challenge the right of the canvassing board to make this determination on just these boxes of votes. Sort of like Gore versus Bush in 2000. So 2 years later, we have a repeat here in Minnesota. So Coleman brought the question here on petition and also appealed the contest here, where it was argued at length in the contest. So Franken was seated quite late. Just a moment here. I should have a coffee mug here for this presidential election. I'll have to have one made. Now, the petition of Coleman was denied in part, granted in part. And in granting it in part, the court wrote in footnote note 13, it said 2 things, which were essentially a wash. Essentially what it says is that of the 4 subsections, A, B, C, and D, of 204B.44, only one of them didn't deal with ballot issues. The one exception is D, in the very same footnote on which the other exclusions from the petition arena now have all been predicated, starting with this Coleman versus Ritchie and then cited in Minnesota Majority versus Ritchie. And all it says is that, however, Section 204B also allows the court to correct any wrongful act, omission, or error of any election judge or any other individual charged with any duty concerning an election. 204B.44D. So this is at the tail end of that footnote. And so, thus, to pretend to rely on this note 13 to preclude or exclude any petition from a hearing where people can be called and told to follow the election law is a travesty, because it specifically says the court can correct any of these things, and you did not decide that any other thing could not be included. That is just a falsehood. Nor does the context of this ambiguous statement support barring any claims that conform to 204B.44D from this court. You found in part, petitioners invoked our jurisdiction in this matter, this is Coleman did, under Section 204B.44, which allows us to order the correction of any wrongful act, omission, or error of any individual charged with any duty concerning an election, unquote. And then comes the note 13. And you concluded, we agree with petitioners that whether absentee ballots were rejected erroneously may be addressed in an election contest under 209. Nevertheless, because that's a contest, this is a petition. Nevertheless, we disagree that the relief must be entirely denied in this proceeding under Minnesota Statutes 204B.44. We rejected the argument that a county canvassing board could not be revived after its initial canvass, but not because the statute required that conclusion. Rather, we explained that the court's authority to order correction of errors under Minnesota Statutes 203.38 from 1961, that's the predecessor to Section 204B.44, it should not be negated. Accordingly, we conclude that in a specific and limited circumstances where all parties, the 2 candidates, and all the relevant local election officials agree, Section 204B.44 authorizes us to allow correction of that error to reflect, quote, the true vote of the people, unquote, which is, after all, isn't that what we're after here? And the correction need not await an election contest under Chapter 209. So where does the court believe this footnote, which essentially sought to balance the use of the contest and petition in a hotly contested recount, and to balance the reliance on the principal use of pre-election ballot questions, would you say, and post-canvass adjustments under D. How could this possibly preclude the enforcement of voting rights, First Amendment, equal justice, and ballot access issues from the scope of the correction provision? So candidates and FCC licensees each have duties in arranging publicly broadcast candidate debates under the First Amendment and equal time provisions, not to prevent free expression and free association, constitutional rights of independent voters. And furthermore, the Minnesota courts have a duty to enforce these laws in the election. Therefore, this fits under D of 204B.44. And the same could be said of each of the grounds. This is just analyzing the debate question. In Smiley Supra, the Supreme Court commented on Minnesota election laws and said, quote, "The subject matter is the times, places, and manner of holding elections for senators and representatives. It cannot be doubted that these comprehensive words embrace authority to provide a complete code for congressional elections." I call that the CCEC. Not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved. And these requirements would be nugatory, they would be useless, if they did not have appropriate sanctions in the definition of offenses and punishments. All this is comprised in the subject of times, places, and manner of holding elections, and involves lawmaking in its essential features and most important aspect, unquote, United States Supreme Court to Minnesota in 1932. How soon we forget. Now, in addition, as noted supra, Article 1, Section 4 also empowers the Congress through law, and that includes the formulation of the amendments to the United States Constitution. The 1st, the 14th, the 15th, and the 19th. All of these requirements, which the Supreme Court said the framers intended to say cannot be made nugatory, useless. And for this, the legislature had to make appropriate sanctions in the law, and definition of offenses and punishments. And under Article 1, Section 5, the U.S. Senate in 2014 and the U.S. House in 2012 would be the final judges. They retain the power under Section 4 at any time to act by law to continually make or alter these same regulations. It is clear that these regulations correspond exactly to the requirements referred to by Hughes and Smiley, and that they need enforcement. Where these regulations and requirements, including constitutional requirements, are not followed, it falls on this court to impose the appropriate sanctions. And 204B.44 provides that at a hearing, the court will order correction and compliance and impose contempt sanctions if they do not. So what this court has been really arguing is not that these infractions of free speech, voting rights, equal justice, and ballot access cannot be ruled on by the court because somehow these matters through regulations cannot find a forum, or though regulations they can't find a forum. They are tacitly throwing them all into the category of cannot be heard, cannot be enforced, a kind of electoral twilight zone. It is further noteworthy that there has been a change from this court's decision in Carlson versus Ritchie, 2013, and Carlson versus Franken, 2015, the instant petition. In 2013, the claims of voting rights, the ground 1, and ground 2, First Amendment rights and use of public information, voter emails, were not at all ruled out as matters that could not come in under 204B.44. And yet this was 4 years after the Minnesota majority, which is now relied on to exclude everything. They could, it was clear, if the asserted rights were acted on diligently, so as not to injure the top vote getters' entitlements. Perhaps this was infirm legal reasoning, which is being jettisoned today. But latches were invoked on these, and the only claim that was treated with the not any and all disputes concerning official conduct that relates to an election reasons for dismissing the petition was the one most clearly related to the administration of a federal election, the availability of an election contest to collect evidence and forward it to Congress. Not for this court to create outcomes in those contests which could cause disagreement by contestants, as they say, now I agree with the outcomes. Well, the outcomes were simply that they said I didn't bring it soon enough against Betty McCollum. But that's a different election. This petition, this contest, are tied directly to the 2014 election and in anticipation of the 2016 presidential election. Now here's some federal cases. In Ex parte Yarborough, 110 U.S. 651 from 1884, Congress made and altered regulations of the time, place, and manner of states selecting members of Congress by passing a law calling for punishment of those who assaulted black voters in a congressional election to intimidate them. The state of Georgia objected, and Justice Miller set out, in his opinion, just where the power of the states to prescribe and implement federal elections, okay, couldn't go down in their state elections, but for an election for senator or representative, the Congress could jump right in. And it comes from the U.S. Constitution, and he wrote in support of regulating federal elections, quote, "If this government, federal government, is anything more than a mere aggregation of delegated agents of other states and governments, each of which is superior to the general government, it, the federal government, must have the power to protect the elections on which its existence depends from violence and corruption. If it has not this power, it is left helpless before the two great natural and historical enemies of all republics, open violence and insidious corruption," unquote. What the court is doing in refusing to allow these serious, material, and deliberate issues of voting rights, equal justice, First Amendment freedom of association and expression for independent voters, and ballot access protection, the protection of all these voting rights, which was specifically spelled out in Hughes' broad description of the procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved, and the appropriate sanctions in the definition of offenses and punishments so as not to render these requirements nugatory. The refusal to enforce this will make the U.S. Senators mere agents of the two national parties in each state, Democrats and Republicans. With this court, its foot on the brake of the engine of electoral justice as their shepherd. This is, in some people's opinion, already rendering the federal government helpless before the foes of all republics. The Constitution of our republic requires that the court protect the voters against this and to fight corruption of free and fair elections so they will be pure. Nowhere does the Constitution of Minnesota or Minnesota Elections Code give to the FCC the role of protecting free and fair election debates. The FCC has not preempted the field of protecting free speech, freedom of political expression, and political association in Minnesota's federal elections. And yet, this court refused to regulate this in October 2014, even to consider the very same questions answered in 2002 under 204B.44 in Moore versus MPR, Minnesota 2nd Judicial District, 2002. In that case, Judge Monahan wrote, quote, "The fact that access to media is in the legally unfettered hands of private bodies has sobering implications for the vitality of a democratic system." This was a ruling against the Independence Party Senate candidate, like me, okay, based but just on one last-minute election, not a whole season. So that still needs to be addressed. Can you wipe out the party arbitrarily and for the whole election series or season so that Al Franken can pretend that he's untouchable, that he has somehow all these great ideas about the Senate and the United States government that Rush Limbaugh couldn't come up with, ordinary Americans can't come up with, but he doesn't have to debate. So this court's job in enforcing the full scope of the election code, including debates, including voting rights, including equal justice, and including ballot access issues, is to shore up the vitality of our Republican form of elections for the reasons stated by the Forbes Court below. And I'm going to leave this remaining discussion of some of these issues and the reasons why clearly these are matters which the Minnesota Supreme Court must deal with because they are committed to them. For a fourth video, I'm Steve Carlson. I'm running for President of the United States, and I approve this video, and thank you for watching, and hope that you will closely study the battle over voting, which is already starting in the presidential election. And I guess I feel like I'm kind of riding that wave of a huge tide coming in.